Welcome to this session by Pro-Legal Minds on Judgment and Decree, Key Elements of Civil Litigation under the Code of Civil Procedure, 1908. These concepts are fundamental to the judicial process, with judgment providing the court's reasoning and legal analysis behind a decision and decree serving as its formal and enforceable outcome. In this session, we will explore the definitions, types, and procedural significance of judgments and decrees, along with key provisions and examples to deepen your understanding of how courts determine and document the rights of parties in a suit. Let's begin. A judgment is the final decision of the court on the issues raised in a suit, based on an analysis of evidence, facts, and applicable law. It is defined under Section 2 of 9 of the Code of Civil Procedure, CPC, 1908 as the statement given by the judge on the grounds of a decree or order. A decree is the formal expression of an adjudication by the court that conclusively determines the rights of the parties concerning the matters in controversy in the suit. It is defined under Section 2 of the CPC, 1908 and may be either preliminary or final. 2. Explanation of judgment, decree and types. A judgment is the court's reasoning and decision on all issues raised during the trial. It serves as the basis for the decree or order. Judgments must be clear, logical, and explain how the evidence and legal principles were applied to reach the decision. A decree is the operative part of the judgment, formally recording the court's decision on the rights of the parties. Types of decrees. 1. Preliminary decree decides only a part of the case, leaving other issues to be decided later, for example, determining shares in a partition suit. 2. Final decree resolves all issues in the suit and concludes the proceedings, for example, actual division of property in a partition suit. 3. Partly preliminary and partly final decree contains both preliminary and final decisions on separate issues in the same suit. Relevant CPC sections: Judgment, Section 33 and Order 20 of the CPC. Section 33 mandates that the court must pronounce judgment after the hearing of the case. Order 20, Rule 4 of 2, requires that the judgment must contain a concise statement of the case, the points for determination, the decision on those points, and the reasons for the decision. Order 20, Rule 3, states that the judgment must be signed and dated by the judge when pronounced. Decree, Section 2 of 2 and Order 20. Section 2 of 2 defines decree as the formal expression of a court's decision that conclusively determines the rights of the parties in the suit. Order 20, Rule 6, provides for the preparation of a decree based on the judgment, specifying the relief granted or denied. Section 152 allows correction of clerical or arithmetical errors in the decree. Decree, Section 2 of 2 and Order 20. Section 2 of 2 defines decree as the formal expression of a court's decision that conclusively determines the rights of the parties in the suit. Order 20, Rule 6, provides for the preparation of a decree based on the judgment, specifying the relief granted or denied. Section 152 allows correction of clerical or arithmetical errors in the decree. Difference between judgment and decree. Judgment. 1. Statement of reasons by the judge. 2. Explains how issues are resolved. 3. Not enforceable directly. 4. Defined under Section 2 of 9. Decree. 1. Formal expression of the decision. 2. Operative part that determines rights. 3. Enforceable through execution. 4. Defined under Section 2 of 2. 4. Examples. 1. Judgment. In a suit for recovery of money, the court examines evidence and legal arguments, concluding that the plaintiff is entitled to the amount claimed. This reasoning constitutes the judgment. 2. Decree. Following the judgment, the court issues a decree directing the defendant to pay the plaintiff 100,000 rupees with interest. 3. Preliminary and final decree. In a partition suit, a preliminary decree determines the shares of co-owners, while a final decree divides the property physically among them. 5. Reference case laws. 1. Balraj Taneja v. Sunil Madan, 1999. The Supreme Court clarified that a judgment must state the reasons for the decision to ensure transparency and accountability in judicial proceedings. 2. Shainkar v. Chandrakant, 1995. The Court explained the difference between a decree and an order, emphasizing the conclusiveness of a decree in adjudicating the rights of the parties. 3. Venkata Reddy v. P.T. Reddy, 1963. It was held that a preliminary decree is binding and enforceable unless set aside, and a final decree concludes the proceedings. 6. Conclusion. Judgment and decree are integral components of the judicial process under the CPC, 1908. A judgment provides the reasoning and legal analysis behind the court's decision, while a decree formally expresses the outcome, determining the rights and liabilities of the parties. Governed by Sections 2 of 2, 2 of 9, 33, and Order 20, these elements ensure clarity, finality, and enforceability in civil litigation. The distinction between the two helps maintain procedural consistency and legal efficacy in the administration of justice. Thank you for watching this session by Pro Legal Minds. We hope you found the content insightful and helpful. Don't forget to subscribe to our channel for more valuable legal insights and updates, youtube.com/prolegalminds. If you have any legal questions or need assistance, visit us at prolegalminds.com to connect with our expert team. We're here to help you navigate the complexities of the law with confidence. Stay informed. Stay empowered. See you in the next session.